You know that feeling, right? That little spark, that light bulb moment when an idea just hits you and you think, wow, this could be something big. We've all been there. But what's the next step? Well, today we're going to pull back the curtain on the entire patenting process. Let's get right into it. So you've got this amazing, game-changing idea. But then the next thought hits you. In a world with billions of people, how do you make sure your idea stays your idea? How do you plant your flag and say, hey, I thought of this? Well, that's exactly what we're here to talk about. The answer, my friend, is a patent. All right, let's put a definition on the board. What is a patent, really? At its core, it's a deal. It's a legal agreement that gives you, the inventor, the exclusive right to your invention. Think about that, exclusive. That means you get to decide who can make, use, or sell your invention. It's like a government-backed no trespassing sign. But there are two key catches. It only works in a specific country, and it doesn't last forever.
So here's our roadmap for today. We're going to break this down into 5 easy-to-follow sections. We'll start with your homework, the prior art search. Then we'll figure out which type of application is right for you. After that, we'll get into the nitty-gritty of forms and where to file. Then we'll talk about how long your patent actually lasts. And finally, we'll cover how to make sure it stays valid. Okay, first up, and I can't stress this enough, this is probably the most critical step of the entire journey, the prior art search. This is your foundation. Before you do anything else, before you spend a single rupee on filing fees, you have to do this homework. Trust me, it'll save you a world of trouble later on. So what in the world is prior art? It sounds super technical, but the idea is simple. It's basically everything. It's any piece of information anywhere in the world that has been made public before you file your application. And I mean anything. Other patents, sure, but also scientific articles, things sold online, a presentation at a conference, even a blog post. If it's out there, it's prior art.
So why go through all this digging? Well, it's not just about checking a box. First, it helps you really understand what problem you're solving. You get to see what other people have tried, which can actually make your own invention even better. But the big one, of course, is proving that your idea is genuinely new. And just as importantly, it keeps you from accidentally stepping on someone else's patent, which is a situation you definitely want to avoid. This whole search really boils down to 3 golden rules for your invention. To be patentable, it has to check 3 boxes. First, it has to be new. Brand new. Your prior art search proves this. Second, it has to be non-obvious. This means it can't just be a simple logical next step for someone who's an expert in the field. You can't just patent painting a hammer red. And third, it has to be useful. It needs to have a practical application. All right, so you've done the deep dive, you've done your prior art search, and you're confident your idea is unique. Awesome. Now it's time to actually get the ball rolling. So let's talk about the different ways you can file your application, because you've got options. First up, we have the provisional application. This thing is an inventor's best friend. Let's say your invention is maybe 90% there, but you're still tweaking it. A provisional application lets you plant your flag and secure a filing date, what's called a priority date. Think of it like saving your spot in line while you finish up your work. It's a brilliant first move. Now that provisional application starts a countdown clock. You have exactly 12 months. Before that year is up, you have to file the main event. The non-provisional or complete application. This is the whole shebang. It needs every detail, every drawing, and the super important legal claims that define exactly what you're protecting. This is the document that the patent office will actually examine. But what if you're thinking bigger than just one country? This is where the convention application comes in. Because of international treaties, if you file first in India, you then have a 12-month window to file in other member countries. And the best part? All those other countries will honor your original Indian filing date. It's like a time machine for your patent application, letting you go global. Let's move on to the nuts and bolts. We've talked strategy, now let's talk logistics. Section 3 is all about the actual filing process, the paperwork, the fees, and the rules of the road. This is where your great idea meets reality. No big surprise here. When you're dealing with a government agency, there's gonna be paperwork. Every single step has a specific form that needs to be filled out just right. And yeah, each of those forms comes with a fee. It's just part of the process. Now, take a look at this table. What's really cool here is the way it's structured. See how a natural person/startup pays way less than others? For an initial filing, it's 1,600 rupees versus 8,000. That's done on purpose to encourage individual inventors and small companies. But also notice the renewal fees. They start small but get much bigger toward the end of the patent's life. Okay, this is a huge rule. You gotta get this right. If you are a resident of India, you absolutely must file your first patent application in India. You can't just decide to file in the US or Europe first. Think of it as a home country first rule. It's a critical point of jurisdiction, so don't overlook it.
So let's fast forward. You did everything right, you navigated the process, and you get that beautiful email, your patent has been granted. Congratulations. The big question now is, how long does this party last? Let's talk about the lifespan of your protection.
The magic number is 20. 20 years. That's the standard term of a patent in India. For 2 decades, you have exclusive rights. But here's the crucial detail. That 20-year clock starts ticking from the day you filed, not the day your patent was granted. Remember that priority date? This is why it's so important.
But, and this is a big but, you don't just get those 20 years for free. It's not a set it and forget it deal. To keep your patent active, you have to pay annual renewal fees. Think of it like a subscription. If you stop paying, your patent lapses and your invention becomes public property, free for anyone to use.
Okay, on to our final section. And it's an important one because getting a patent isn't the end of the story. You might think it's a permanent, unbreakable shield, but it's not. A granted patent can be challenged, and sometimes it can even be taken away. So how can a patent get revoked? Well, take a look at this list. Does it look familiar? It should. It's basically all the rules we talked about at the very beginning. If it turns out the invention wasn't actually new, maybe some prior art was missed, it can be revoked. If it's shown to be obvious or not useful, it can be revoked. This just proves how incredibly important it is to get all that prep work right from day one. So let's zoom out and recap the whole journey. Step 1, do your homework. A deep prior art search is a must. Step 2, choose your application type, your strategy. Step 3, file correctly with the right forms, fees, and in the right place. And step 4, keep your patent alive by paying those all-important renewal fees.
And there you have it, the inventor's roadmap, from that first spark of an idea all the way to a legally protected invention. It might seem complicated, but it's just a path with clear steps. So now that you know the way, the only real question is, what's that brilliant idea you're going to protect first? Thanks for watching.